call to order the meeting of the Michigan Board of State Canvassers. First, I want to welcome two new canvassers, Paul Cordes to my right and Heather Cummings to my left. We have had a really collegial and wonderful board over the last years, and we expect that to continue. And we really welcome your support. We think that you're going to find it an interesting and rewarding appointment.
Thank you.
The next item on our agenda is the election of the chairperson for the Board of State Canvassers for a term ending February 1st, 2027. I will nominate Richard Hauskamp. We have any other nominations? Call the question.
We need a second.
All in favor?
Oh, sorry, Chair, we need a second.
Support.
Oh, we need a second before.
Okay, I'm sorry.
A second.
Do we have a
Member
second?
Cordes
Okay,
seconded.
Member
Support.
Cordes seconds the motion. Okay, all in favor? Aye. The motion carries, and I'm going to pass.
Why, thank you.
It's an official ceremony.
You want me to use my left hand or my right hand? Item 2 is the election of the vice chairperson for the Board of State Canvassers for a term ending February 1, 2027. I move that the board elect Mary Ellen Gurwitz as vice chairperson for the Board of State Canvassers for a term ending February 1, 2027.
I second that.
All in favor?
Aye.
Right. Thank you. I have 2 items on the agenda here. The first item is a resolution to recognize Jeanette Bradshaw for her service on the Board of State Canvassers. And we have a certificate. We're going to break for those in a minute.
Sorry, I should give it to you. Jeanette's first.
We'll do these and then we'll break for a minute and sign them. How's that? We were just delaying time until Tony showed up.
Old school.
Old school, yeah. And we have another resolution here to recognize Anthony Daunt for his service on the Board of State Canvassers. And so we recognize both of you as former colleagues and people we really, really respect and enjoyed time with. And we even have certificates for you. There's a store up the street if you want to buy it. So what we're going to do is we're actually going to recess for 5 minutes so that we can sign your certificates and that we are not stuck.
Read it.
Oh, I'm sorry, I need to read these.
Yeah.
Oh, forgive me. I will read them both. Will we read the whole thing? Outstanding. Okay, State of Michigan, resolution in recognition of Jeanette Bradshaw. Whereas since her appointment to the Michigan Board of State Canvassers in 2013, Jeanette Bradshaw has demonstrated steadfast commitment to upholding election law and shown exceptional dedication, integrity, and service in ensuring the fairness, accuracy, and transparency of Michigan elections. And whereas Jeanette Bradshaw has consistently upheld the principles of democracy by providing impartial oversight and fostering public trust in the certification of elections. And whereas Jeanette Bradshaw has served as chair of the Board of State Canvassers on several occasions, but most notably during the 2020 presidential election, where she chaired the board with unwavering commitment to Michigan's electoral process during the COVID-19 pandemic, and while facing challenging and unprecedented obstacles to the board's ability to fulfill its responsibilities and uphold the democratic process. And whereas as a member of the Board of State Canvassers, Jeanette Bradshaw has served as a valued public servant, applying laws governing ballot access, petition circulation, canvassing, recounts, and certification. And now therefore be it resolved that the Michigan Board of State Canvassers recognizes Jeanette Bradshaw for her service on the Michigan Board of State Canvassers and for her dedication to the Michigan electoral process. and to this board. Be it further resolved that a copy of this resolution may be presented to her. That a copy of this resolution be presented to her as an expression of our gratitude. We have a resolution in recognition of Anthony Daunt. Whereas since his appointment to the Michigan Board of State Canvassers in 2021, Anthony Daunt has demonstrated a steadfast commitment to upholding election law and shown exceptional dedication, integrity, and service in ensuring the fairness, accuracy, and transparency of Michigan elections. And whereas Anthony Daunt has consistently upheld the principles of democracy by fulfilling his responsibilities with integrity and fostering public trust in the certification of elections. And whereas Anthony Daunt served as chair of the Board of State Canvassers during the 2022 election cycle, overseeing the partial statewide recount of 2 constitutional amendments and more than 150 challenges appealed to the board, all while facing challenging and unprecedented obstacles to the board's ability to fulfill its responsibilities and uphold the democratic process. Whereas as a member of the Board of State Canvassers, Anthony Daunt has served as a valued public servant, applying laws governing ballot access, petition circulation, canvassing, recounts, and certification. Now therefore be it resolved that the Michigan Board of State Canvassers recognizes Anthony Daunt for his service on the Michigan Board of State Canvassers and for his dedication to the Michigan electoral process and to this board. Be it further resolved that a copy of this resolution be presented to him as an expression of our gratitude. Thank you. Now we will be in recess for 5 minutes while we sign in pictures. Item number 5 on today's agenda is a consideration of the minutes, the meeting minutes for the December 16, 2024 meeting. I have a motion.
So moved.
Is it all in favor?
Second. No, we need a
Second.
second, sorry.
You don't, we're good.
Wait,
Okay.
Second.
Paul make a motion?
I did.
You did.
Okay.
All in favor?
And I said.
And you said.
Ah,
All in
aye.
favor?
Aye.
Perfect. Item 6, we've got an approval for the following dates for the Board of State Canvassers regularly scheduled 2025 meetings. I'll read those. March 21, 2025.
Yeah, can I raise a question
Oh,
about the
yes,
minutes?
sure.
The signature blocks include member Bradshaw and member Dawn. How are we supposed to sign these?
They just don't sign.
They're still here. But they're no longer.
They technically
I'm
should
only
be.
doing it if I get to stay.
This must happen every cycle.
We should have swapped it, actually.
I'm sorry.
We should have actually swapped it to member Cummings and member Cortez. and you
So
can't
I
use that.
think we could just
Awesome.
write in their names.
Yeah, we'll fix that and then.
Okay, all right.
Yeah.
We'll reprint that and then we'll just do that. We're good?
We're good.
Back to our reading of the dates. We read the March 21, 2025, April 18, 2025, May 16, 2025, June 20, 2025, July 18, 2025, August 25, 2025, September 19th, 2025, October 17, 2025, November 24th, 2025, December 5th, 2025, and December 19th, 2025. And those meetings will be held at the Binsfeld office building in Lansing. Any discussion on these dates or?
Well, I'll just note that because these are regularly scheduled, there won't be a specific meeting notice for the meetings, but we will provide information on the Board of State Canvassers website about what will be on the agenda that day. If we do need to schedule additional meetings, which sometimes happen that are not on these dates, or if we need to change the time or the location, we'll put out a meeting notice for that. But otherwise, we will hope to meet on these dates and minimize the number of changes needed.
Perfect. And these dates work for everybody, so I think everybody's had a chance to look at those. Okay. The next item on our agenda is the
I
consideration.
think
sorry, I
we
have
need
to
a
approve it.
motion.
Oh, yes, we do, don't we? We need a motion for the dates.
I move the Board of Canvassers approve those dates for the calendar year 2025.
Second.
All in favor?
Aye.
Item number 7 is the consideration for the certification of the Dominion voting systems. And specifically, this is for Democracy Suite 5.20.
Sure, I'd be happy to provide a
Thank you.
bit of a description here, Chair Housekamp. So this certification is one of the board's primary responsibilities. One of the checks that we have in our system under the election law is that the Board of State Canvassers certifies the voting equipment that we use in the state of Michigan and also any changes to the configurations of the voting system that we use. We typically have 4 different types of changes to voting systems that occur periodically. The biggest one, the most consequential one, is when we actually approve the vendors that can be used. So that last happened about 8 years ago, and we're actually coming up on the end of that contract. So over the next election cycle, we will be going through another purchasing process and recommending for the board to approve what voting system vendors can be used in Michigan, period. So currently the 3 that are approved are Dominion, which we're looking at today, as well as Hart, InterCivic, and ES&S. Election systems and software. So that's the biggest kind of change we have that happens every 10 years, and that will be presented to the board. In the future, after an extensive process, we're putting out requirements, getting consultation from election officials, and putting sort of that big picture thing together. The second kind of change we see is sort of a full version change, which is not what we're looking at here, but that would be like something, we're going from version 5.17 to 5.2. If there was a bigger version change, like a 6.0, that would be a little bit more extensive in terms of the change to the equipment, to the operating systems, the software. That would be a major change, and we would have certainly very extensive testing on that. One thing I'll note about that is in the future, we're starting to see voting system vendors that are getting their equipment certified to the updated voluntary voting system guidelines that the Election Assistance Commission has put together. Most systems are still certified under the older guidelines, which are still acceptable and still used. But over the next couple of years, we're expecting to see new versions of the voting systems certified under the updated guidelines. What we're looking at here is sort of the third kind of change, which is a version upgrade. So it's still a substantial change. There's changes to the way the software works and additional functionalities that are added. But again, this is going from like a 5.17 to a 5.20. And then the last type of change we see is what's called a de minimis change. That's a kind of change that doesn't affect the overall operation of the system, but might be changing a component like a commercial off-the-shelf component, like a printer or a monitor. Not a major change, but still something that the Board of State Canvassers approves because we're changing the equipment that's being used with the system. So we're in a version update here. Anytime that changes are made to voting systems, there's an extensive process that occurs prior to us bringing it before the Board of State Canvassers. So first, election equipment, in addition to being certified at the state level, is also reviewed at the federal level. That's done by the Election Assistance Commission, the EAC. And similar to the Board of State Canvassers, that's a 4-member body that has 2 Democrats and 2 Republicans. And so they will review and certify voting equipment. Before they do that, the voting equipment is reviewed by a voting system test laboratory, sometimes called a VISTL, another acronym, apologies, but the voting system test laboratories have to be accredited by the National Institute of Standards and Technology, or NIST, another one. So that is, sort of an expert laboratory that has been accredited and certified by the Election Assistance Commission to review the voting systems in depth. So before they come to even the Election Assistance Commission, and certainly before they come to us, there's an extensive process by which these test laboratories really dig into the technical components of the systems, review the functionality, and that's the most in-depth technical review that these systems get. But following that, we at the Bureau of Elections also do our own testing. Following, we review the reports from the Voting System Test Laboratory and the Election Assistance Commission. And then we also ask the vendors to come in to the Bureau of Elections and demonstrate the components to us. We also ask some of our local election officials to participate in that. And in this case, we had the Wayne County Clerk and staff, the Kent County Clerk and staff, Jackson County Clerk. We also had City of Taylor Clerk and Brownstown Township Clerk. Dominion voting system is the most commonly used system in Michigan. It's used in 65 of our counties, including Kent and Wayne. So we certainly wanted to have the input of the officials that use it on a day-to-day level more than we do as we're going through these components. So I really appreciate, again, Wayne County, Kent County, Jackson County, as well as Brownstown Township and Taylor for taking time out of their very busy schedules and braving the weather to come to Lansing to help us review these components. So we also had Dominion and Election Source, which supports Dominion in Michigan as we were going through these components. So we spent 2 days going through, reviewing some of the changes, making sure that the functionality was working as expected. And we also ran tests using test ballots and simulations to make sure that the equipment was working properly. So we did find that everything worked as expected. A couple of the major changes or improvements that we have with Dominion 5.20 versus 5.17. We have an updated operating system and some updated software on the election management system. There have been improvements to make some of the components compatible with the web content accessibility guidelines to make sure that the software is more modern and accessible. There have been some improvements made to the scanners that would prevent users from accidentally running reports they shouldn't be running until after the election is over. And then also, we probably most notably for Michigan, we have a correction to one of the issues we encountered last election with the accessible device. So we had an issue that was affecting some users who wanted to use the voter assist terminal or the ballot marking device. If they selected straight party and then tried to select individual candidates of the other party, instead of retaining the straight party selection and letting them pick one by one, they would have to go back and deselect the straight party. So that was inconvenient for voters, and so that's been corrected. So when we're looking at the voting system, I should have probably said this earlier, but there's basically four major technological components of the voting system. There's the election management system, or EMS. That's the computer and the software that is housed at the county, and that's used to design the election, program the drives that are put into the tabulator. So that's really like the brains of the voting system, and where most of the changes and most of the software are housed. Then we have the tabulator. That's your basic precinct scanner. So when you go to vote at a polling place, that is basically just a scanner. It scans the paper ballots. And it is programmed by a removable drive, and that drive is programmed again by the election management system computer. The third component are high-speed scanners. Those are similar to tabulators, but they're used only to count absentee ballots. So when we have absent voter counting boards, particularly in our larger jurisdictions where there aren't voters there, but instead election inspectors that are putting absentee ballots into the tabulators, those are high-speed scanners. So if you're putting through thousands of ballots, they're much more efficient in counting the ballots, but they essentially work the same way as the tabulators in the sense that they're scanning paper ballots. And the last major component is what we call the voter assist terminal in Michigan, which is a ballot marking device. So that's a device that assists voters in marking a paper ballot. It can be used by voters with disabilities, but it can be used by any voter who wishes. And basically that is a device that has a touch screen. It has compatibility with accessibility equipment to allow voters to mark the paper ballot, which then gets printed out and then that gets put in the tabulator. So those are the components that we're looking at as we were doing this testing. Again, we found based on the demonstration that it did function as expected. And so we are recommending certification at this time. The next steps following certification will be updating all of the equipment in our 65 counties that use Dominion so that it can be in place for the upcoming elections this cycle.
Does anyone have any questions, comments? Questions for Director Brady? Without any discussion or further discussion, I would ask that we would have a motion.
I move that the board certify the Dominion Democracy Suite 5.20 voting system for the use in the state of Michigan.
Support.
All in favor?
Aye.
Moving along. Item number 8 on the agenda is a discussion of the investigation into the qualifying petitions submitted by Cornell West. And I think when we broke before the holidays, we had talked about, well, we had some material that had been received. We talked about sending a letter. Has there been any changes on that or updates on that?
Yeah, I can provide some updates on that. And Adam, if I miss anything or say anything incorrectly, I'm going to count on you to help solve that problem. So we did contact the Attorney General's office on my behalf, sent a letter to the campaign seeking information about the circulators for everyone's benefit, since we have some new members. What this issue involved was the petition that was submitted by Cornell West to qualify for the ballot for president. The Bureau reviewed the petition and determined that there were a sufficient number of signatures, valid voter signatures, the signatures in the actual petition to warrant certification, that he had enough valid signatures on the petition. And the board agreed and certified into the ballot. However, there was a challenge during the process, not only to the signatures by the petition signers, which are in the main section, but also the signatures by the circulators. So petition circulators have to sign the circulator block that basically, identifies them and includes their signature. And one of the challenges that we saw was alleging that some of these circulator signatures may have been fraudulent or may have been forged or may not have belonged to the people whose names were actually on that circulator block. So we didn't really have a process for reviewing challenges to petition circulators. And one of the challenges that we have with that is that you don't have to be a Michigan registered voter to be a circulator. So if we get a challenge to a voter signature, we can look that up in the qualified voter file where we have an image of their signature and compare what's on the petition to what's on the qualified voter file. But we don't have that for circulators unless the circulator happens to be a Michigan registered voter, in which case we do. So I think out of the 62 circulators, I believe 28 of them were Michigan registered voters as far as we're able to determine. So we were able to review those. But for the other 34, math on the fly, 34, we would need information about people who aren't Michigan registered voters, which we don't have at the Bureau of Elections. We don't have that at our disposal. So we contacted the campaign and asked them to provide information, signatures that we could review for those circulators to compare them to the circulator blocks and see if those were valid. We were able to get, I believe, 14 out of the remaining 34. We were able to get copies of their driver's licenses from the campaign. So between the 28 who were registered voters and the 14 that were out of state where we had a driver's license, we were able to review 42 of the circulator signatures. And we reviewed them, and by and large, we did determine that those signatures on the circulator block did match what was on file. So I think it was out of about, I don't know if I have the exact numbers here, but it was out of about out of 117 of the signatures we had, circulator signatures we had with the driver's license, 112 of the circulator block signatures matched those. And out of the ones we were able to check in qualified voter file, 252 of those 252, 248 of the circulator block signatures matched. So when we looked at what was in the sample that we used to determine if they had enough signatures, we were able to review 369 of the signatures in the sample, which was about 560, and about 360 of those did match. So it doesn't look like, based on what we were able to tell, that there was a widespread issue with the circulator signatures not matching. It appears that most of them did match. The only thing we don't know is the other 20. And in terms of the other 20 circulators, the Bureau of Elections doesn't on its own have the ability to compel the production of those 20 circulator signatures. So based on what we saw, it doesn't look like there was, there were a few that didn't match, but it doesn't look like there was a widespread mismatch between the circulator signatures. But we were not able to look at the entire universe because we don't have those other 20 circulator signatures. Is there something you want to add or correct, Adam?
Nope.
So moving forward with this, it would be nice to get it to a point where either there's a next step or there's a conclusion, and then something is in the record for the conclusion. Now, excuse me, because I'm brand new at this. So if I mess this up, call me on the carpet. But we've got Mr. Brewer here, and he was part of the original request for investigation. And so I'm going to ask him if he wants to make any comments. Are we okay there?
Yes, thank you, Mr. Chairman. Mark Brewer of Goodman Hacker. I appreciate all the work that the staff has done and the board has done to follow up on the court order that you investigate the circulator signatures. But it appears that your investigation is incomplete because at least 20 of these signatures haven't been examined. So I think there's more work to do to complete your investigation before you reach any conclusions.
Is it, of the 20 out of states that we can't easily access? Do we have any idea how many signatures or how many petitions those 20 represented?
Well, based on the sample, so I mean, out of the 42 circulators out of 62 that we reviewed, those represented 369 out of what, 576 in the sample. So that would mean there were 207 signatures in the sample that were submitted by circulators whose signatures we don't have to review. So that's about 2/3 maybe of the petition as represented by the sample that we're able to review. So, you know, it seems unlikely to me that it would have affected the determination that the petition was sufficient, because we looked at about 2/3 and almost all of them matched, and based on the original finding, they were well above what they needed. But we wouldn't, you know, we would need to review the others to be sure. But then there's a separate issue of, irrespective of whether the petition was sufficient for a qualification for the ballot, there's a separate issue of, you know, potential investigation, criminal investigation of the circulators. So that's something that we would just need more information. And again, the Bureau of Elections doesn't have the ability to compel that information to be produced to us.
The Bureau doesn't have the ability, but the board does have the ability to compel the production of the signature samples. I mean, I just read again the direction from the Court of Appeals, which noted that we have subpoena power. So while this is not going to affect, obviously, the Cornell West candidacy, I think that we need to understand that this has implications going forward with investigations that we need to do in the event that this issue arises again. And I think we should consider issuing subpoenas, given that we previously took the step of requesting voluntary production of the information, and that has not been provided.
So question there, when you say issue subpoenas, are you looking at issuing subpoenas to circulators? Or are you looking at issuing subpoenas to Cornell West campaign attorneys? Who would you direct us to?
I think it would be directed to the campaign, which is the entity which has responsibility. But I would ask for guidance from our attorneys on this issue.
Certainly. What's the question that you'd like us to answer?
The question that has been raised is, if we issue subpoenas, to whom do those subpoenas get directed?
That would be a determination for the board to make of who you want the information from. I think it would be possible for you to send subpoenas either to the Cornell West campaign or to the individual circulators.
So you're saying that it could be either or. So Chair Hauskamp inquired about where the subpoenas should be sent.
And I do think that the Cornell West campaign has already produced some information to the Bureau. So I think the question would just be what information or what further information you want the
I
campaign to
think
produce.
that Cornell West campaign didn't provide the information.
They provided some, yeah.
They provided some,
Some.
but less than half of the information that was requested.
Right. So the implication would be that there is more that they're not producing voluntarily.
Right.
Again,
Exactly.
it's entirely up to the board, whatever it's the choice of the board to whom you're issuing subpoenas and what you're requesting them to provide.
You know, one of the challenges we've got here is that this cuts to a much deeper issue. You know, the deeper issue that this goes to, which we talked about through the entire last campaign, is that we're now living in an age where paid circulators and gathering signatures is a very profitable business. And people are coming in from all over the country who are gathering signatures in ways that are basically outside of the purview of the state to even regulate. And so we've been kind of down this road. And so the challenge here is that the court ordered us to conduct an investigation. We have conducted a good faith investigation, I believe. We've gotten driver's licenses, we've gotten identifying information from some of the circulators, the ones that are in Michigan, certainly. We've been able to verify those, Director Brader, against the QVF file. You have evaluated those signatures.
Yes.
And so, and you've evaluated, more importantly, is you've evaluated them without finding fraud in those.
Well, yeah, I mean, for the most part, we did find a few that didn't match, but overwhelmingly, we did not find it.
So there's not a pattern there. So on the one hand, we've done an investigation, and I want to be careful that we don't turn this into every single meeting for the next 2 years with new adventures. But on the other hand, this issue is going to come up again, and we've talked as a board. We've talked about, do we approach, should there be legislation on this? The Bureau of Elections has advised us that this has been brought into court before. There's constitutional issues involved. But the elephant in the middle of the room is still the fact that paid circulators through companies who are making a profit to collect signatures is going to remain an issue. So I'm open to fellow board members here. And I know that's not fair because
This is terribly unfair of you. No, I'm just kidding. No, I agree with you. I think even if this isn't going to help with, I mean, the Cornell West issue is moot, but this is going to become an issue, this continuing on now. And I do think using our powers as a board to compel information is a good way to go. Are you saying that even doing that, you're afraid we're not going to get what we need? Was that?
No, I think that if we look at that, I think if we're talking about using a subpoena to bring in, I don't know that we would even need to speak. We're looking to bring in the Cornell West campaign people.
Mm-hmm.
And to be honest with you, if we bring them in, I would suggest we find a way to bring in the paid circulator organization, the company that they used. But
Right, because wouldn't the company verify, would the company have their license or something with their signatures on it that we could
well,
view?
that would be the supposition. But I also, to finish that thought,
Mhm.
I think if we had a discussion about trying to subpoena out-of-state circulators, I think we need to really seriously maybe not go in that direction. The circulators that we've been in touch with, that we've already seen documentation on, are folks who are typically working, tough jobs. They're not folks who are going to be able to just get on a plane and come out here and travel. I think if we're trying to bring in the individual circulators from places like, we saw some from Missouri, we saw a couple from Arkansas, we saw those I don't think we would bring in.
I'm not suggesting bringing them in. I'm suggesting.
We bring in the attorneys or the
Right,
campaign
but with documentation that we could, to verify signatures.
One of the things that we talked about before was these are paid circulators,
Mhm.
which means that the company
Should
which
have
hired
records.
them, not the campaign. I don't think we want to get into what company the campaign used. It's the responsibility of the campaign to provide, to provide to the board the information that we have requested. And while, as Member Cummings noted, it's moot with regard to West, the failure to respond to our request is one that I think we need to be concerned about going forward. And the Cornell West campaign was one that just kind of, blew into Michigan and left. But we will have a lot of petitions coming our way in 2026. And we want either the candidates or the petition sponsors to understand that they have a responsibility and that we intend to enforce that to force them to comply with that responsibility and to investigate instances, as we are compelled to do by the Court of Appeals, to investigate instances when they don't satisfy their obligations. So I think we need to recognize what this means going forward for our investigatory responsibility.
If we And let me ask, I was gonna say, can we ask a question of the Attorney General's representatives here?
I was gonna just interject, it depends on who we're talking about sending a subpoena to. There's subtle differences in the practical application of that. For example, individual circulators, because they check the box on the circulator, on the petition sheet saying that they acknowledge the jurisdiction of the state of Michigan in any legal proceeding, and they authorize the Secretary of State to receive service on their behalf. That gives us an avenue to, to effectuate service upon them. Mr. West, or Dr. West, and his campaign have voluntarily appeared in Michigan before. They have an attorney present in the state of Michigan, so that gives us an avenue to contact and direct a subpoena to them. The signature gathering company, I think, would be less certain and would present some problems in terms of effectuating and service upon a subpoena upon them.
So would it be realistic to request that the Cornell West campaign, through their attorney most likely, appear before us? And would it also be realistic for us to give them a list of what we are looking for them to gather, for them to bring to that meeting? Certainly they have access to the company they use to collect the circulator, the signature.
Certainly the board can.
And can we request even to the level of saying, as we've talked before on this board, if they hired paid circulators and they brought them to Michigan, or they use people in Michigan, there would be records of payment, there would be records, employee records, or records of some disbursement that went along with that. Can we also request to see those records?
So,
Can you, oh,
I'm sorry, in terms of what the board can request, there's
So you
not
request anything, right?
quite a bit. The statute at issue, section 552 of the election law, provides that the Board of State Canvassers may hold a hearing on a complaint or any other purpose considered necessary by the Board of State Canvassers to conduct an investigation of the petitions. And in conducting that hearing, the Board of State Canvassers may issue subpoenas and administer oaths. Rule 4 under the board's procedures provides that the board may issue subpoenas upon its own initiative at the written request of the secretary of the board or at the written request of a party to the hearing. So what you seek or what you demand in that subpoena, limited within some confines of what is actually relevant or within the scope of what the board is investigating. But so long as it's tied to the investigation, I think you have pretty broad authority.
I just keep coming back as Vice Chair Hurwitz has also expressed. And I'm sure our former board members would also express they were both involved in this as well. There's been a campaign that basically poked us in the eye and said, we're just going to gather signatures any way we want. We're going to do it our way and we don't care. I mean, that's in effect what has been presented to us. I think and the court ordered us to do the investigation. I think if we just simply walk away on it, have we done due diligence, or can we go one more step here and bring in the West people, or bring in the West's campaign people or campaign attorneys? Well, I would defer to you there in terms of who we would subpoena.
I think, again, it's pretty much up to the board. The determination here ultimately is to the board's satisfaction of when it feels that it's capable of making a determination on the complaint. As I read the Holiday opinion, I didn't see a lot of interest in the court in second guessing the board's determination or what you think is sufficient. So ultimately, I think it will be up to the board and when you're ready to make a decision on what you think you need to make that decision.
We did request the campaign to provide the signature samples. And as Director Brader informed us, we only got 14 out of 34 that we requested. So I don't think a further request is in order. It seems to me that at this point we need to issue a subpoena, and I would issue it to the campaign, not to the individual circulators. It is important that campaigns take responsibility. So.
My only take on it, I agree. I also, just in my experience with campaigns, know that, and I look at this more as like a future thing to obviously doing our due diligence on this. I wonder if it would be wise to, because none of these campaigns that are doing this work want to end up in a situation where they're not on the ballot, right? They want to do everything possible to make sure they do end up on the ballot. So I don't know if it's possible for us as a board to put together some direction to some of these campaigns, because I've seen some campaigns that are very organized and some that are extremely disorganized, some that's a campaign of one, some that are campaigns of hundreds. And if we have some direction to these campaigns that are collecting signatures, that is say, hey, if you have people collecting signatures, either paid or volunteer, it might be wise to grab a copy of their driver's license in the event that something like this comes up. But just for us to put some direction out to these campaigns so that in the future, I have no idea if the Cornell West people have any idea, any way of tracking down these folks who are doing that. They may or may not. But I do think that it would be wise for us as a board to give these campaigns some direction as they're doing this. Like I said, some of these folks are very inexperienced. There's a lot of people who have no idea what they're doing on this the signature gathering, especially some of the smaller campaigns or kind of outsider campaigns. So I think that it would be wise for us to not only continue to look, continue this investigation, but look at a way before we have a lot of candidates who are already announcing for the next cycle to give them some advice and direction as a board as to what they can do to ensure that we don't end up in this situation in the future. So that would be my only take on it.
The Bureau of Elections does give substantial guidance to the campaigns through its procedure manuals and its information for candidates. I think it's the responsibility of the campaigns and not of the board to tell the campaigns how they should conduct themselves. But I think by issuing a subpoena in this instance, we would be sending a pretty important message to the campaigns that they have responsibilities which we expect them to carry out. I think it's an important message. And I'm thinking less about the Cornell West campaign than about the situation that we faced in 2022 with so many campaigns that had so many fraudulent signatures. And it is not unreasonable at all to ask them for the signature examples. And I think as we recognize, if they hire signature gatherers, they have a W-4 form from those people so that they can pay them. I mean, the information is readily available, and I would anticipate that they still have that information because they're going to be sending information to the signature gatherers, are they not? They would have an obligation to deduct taxes from those people to whom they paid. So anyway, they're gonna, when you pay people to do work for you, you have information about those people. And we asked them for that and they didn't give it to us. So if we want people to respect the authority of the board in the future, I think we need to do to continue our investigation, although in many respects it is moot.
From a staff perspective, so again, there's a question of after the fact investigating, which the subpoena process is being discussed for that. We certainly, we have updated our guidance to campaigns. After 2022, we certainly added a lot. We incorporated random sampling, which I think overall made the process better in 24 than it was in 22. On this issue of reviewing the genuineness or validity of out-of-state petition circulators, if we were to try to incorporate that into the petition review process, it definitely would raise a lot of questions. I mean, for one thing, if we're reviewing the petition signatures as part of our review, that basically doubles the number of signatures that we need to review. So that's one issue. But then the other thing is, in terms of getting the exemplar signatures, the signatures that we would need to use to verify the out-of-state circulator signatures, we could ask for it, but if they did not provide it, that would be a legal question as to whether there's actually legal authority to require campaigns to provide signatures of their circulators in advance. And again, as we discussed briefly and more in the past, there have been many challenges to the legal requirements that surround circulators of petitions. So that would just be the question. If we actually wanted to incorporate this and be able to look at it at the front end when we're assessing the sufficiency of petitions, I think there'd be a lot of obstacles there. When we're looking at it after the fact, when we have more time, there might be more options there, but it wouldn't really help in terms of determining whether a campaign actually has enough valid signatures to make the ballot.
Your point is, can I bend your point one degree?
Yeah.
You're making a really interesting point on the other side of this too, and that is this Cornell West issue is passed. You've looked at what's come in, we've looked at it, we know that it wouldn't make any difference either way. We know that the numbers were there. It seems like what you're also saying is that the better focus for this board is focusing on the future. And how does that balance with the requirement to do an investigation? What would be the outcome of bringing in the Cornell West campaign? There's not a punitive dimension to this. There's really only an investigative dimension for gathering information. Is that correct?
Well, I mean, that would be sort of outside of my authority to answer, I think. I mean, there would be, an investigation, in 2022, there were investigations that led to criminal charges for some of the companies or some of the circulators involved. So that is one potential outcome, but I obviously can't say as to, what would happen here.
So, we're recognizing that this is an issue that we're going to be dealing with again, with regard to future campaigns and future petitions. So what we do with this one, with this investigatory obligation, is going to affect, we're going to have to come up with a procedure. Let me back up. We're going to have to decide how we're going to address the issue of needing, in circumstances, needing to see the information regarding the circulators when we can't verify their signatures. And as the court said, we can't say we don't have a procedure to verify the signatures of out-of-state circulators. If we have an obligation, a statutory obligation to do that, then we have to develop a procedure. So that's one thing that I think we recognize is on our agenda going forward. But what we do with regard to this one may impact what we decide to do, or at least it probably won't. I see Eric rolling his eyes, but
Just to clarify for the record, I was not rolling my eyes.
I think that was a comment from our attorney, Salento.
I was thinking.
But we do need to say that when we make a request, we made a request and it was not complied with, not fully. And therefore, do we say whatever, or do we say we have subpoena power and we should exercise it? We haven't done it before, but I think the fact that we have that power and the court pointed it out to us, I think that's important. And this is a campaign that probably doesn't have any continuing existence, but it did have, it needed to have, and it had an attorney who appeared before us. And it was that I believe you can confirm that we directed our request for the information to that attorney. So I think that he represented the campaign. I think that a subpoena could be directed to him to comply.
The subpoena would be directed to the campaign and then served upon.
Right.
I believe Mr. Debus was the attorney.
If he would accept service.
If he would accept service,
Right.
which we cross that bridge, I suppose, depending on what the board does.
So I think that this is important for us going forward to figure out how we deal with this issue.
Could I make one suggestion, just a possible way forward here? Rather than issue, or rather than vote on issuing a subpoena or going through that today, could we instead, before the March 21st meeting, could we as a board or a couple of board members generate a list of questions or a list of discovery, a list of whatever it is we hope to, whatever we want to gather from someone from the West campaign standing here. So that this isn't like scattershot, it's, here's a list of questions we're trying to get answered. So that we know exactly what we're looking for, and then come back to the March board meeting, and we can make a decision whether to issue those questions requesting an answer from the West campaign in writing, or whether we issue a subpoena and have them come out. Does that make any sense?
No,
No,
because,
that's okay. That's-
no, because we know what we want from them.
Well,
And that
we do,
is,
but-
we want signature exemplars. That's what we requested. They sent us some. They sent copies of driver's licenses. They have more. I mean, they have to because they pay these people. So I think that, I don't think we have an extensive series of questions. I think we just want them to furnish those signatures, which is what we need to conduct our investigation.
Okay.
Okay.
Um,
So would that be the scope of the subpoena then, just asking for proof of the additional signatures?
Before, yeah.
Yes.
That would be the subpoena, whereas before we simply ask it in a letter, correct?
Yes.
Yes.
That is our understanding.
So right now, the next step to ratchet it up, I'm not the attorney, so the next step to ratchet it up would be to issue a legal request to have them appear in person, or a legal request to have them comply and send documents that we don't have.
I think that'd be entirely up to the board, whether you want the Cornell West campaign to send a representative to appear before the board, or if you want them to produce documents in anticipation of the board's next meeting.
There was some additional documentation I think they sent in their response when they sent the original, or when they sent that partial list of people. Wasn't there something to the effect that, did they have more to say in that letter? Did they send an exhaustive list of what they had, or did they cherry pick it out? How did they determine, how do we know what they gathered, of course?
We can pull that up in a moment. We don't have that.
I mean, the letter that we sent in December gave examples, asked for signature signature samples, and gave examples of what those documents might be that would have samples on them. And so we asked them for everything, right? And they gave us what they had, and that was what they said in the letter, like, this is what we've been able to produce.
That's what they said.
That's what they had.
That was all they could produce.
That was all that they had. And they did indicate they had not hired a company. So this was a volunteer effort. So there's no company, at least per Mr. Debus's letter. So
The point of the subpoena would be to simply shake them a little harder. Is that the
right, it would be a
the
little
layman's
harder,
approach?
which said they may or may
You
not.
got it.
They may or may not respond to it. They may or may not appear. They may not have anything else.
If they don't respond to it, what happens?
We cross that bridge. when
We'd
we
have to
come
cross
it.
that bridge, right?
But I think it shows how serious we
I
are.
think it is
I mean,
serious, yeah.
that's the issue here. And I don't think I mean, in my opinion, and I know it's my first meeting, so I'm not the boss here yet. No, but I don't think we pull anyone here. I think we do a document request subpoena. I don't think, like you had mentioned earlier, that it's a long way to travel for some people. I mean, I don't think we want to make people spend money unnecessarily, but I think the fact that it was ignored is a huge issue. And even for further campaigns to know that the board is going to take it seriously, I think that's very important. And if they ignore it, then we'll cross that bridge. But I think it shows for this year, next year, that we're serious. I mean,
The one that's hidden in this whole process is the organization, the company that they hired, who
Yeah.
hired the circulators. That seems to be the one missing link here that we're not.
well,
Do we
but
have the ability to make requests of them as well?
Well, in the letter, the campaign indicated that they did not hire a firm to
Okay,
circulate. So
they were hiring their own signature gatherers?
that's my expectation based on what they said, is I believe that they were paying folks, but that they were hiring them individually.
Did they say that there was a volunteer aspect to it as well?
I don't recall that. We have to pull up the letter. Yeah.
I'm not sure. I mean, that's
Well-
almost, I'm not sure that matters.
Well, all I know, like, if there is a volunteer aspect to it, there would be a rationale where they wouldn't have a signature for a volunteer, right? That would be the only reason that could potentially matter. Now, realistically, they should be able to reach out to that individual, ask for a driver's license or something like that, but they wouldn't necessarily, a campaign wouldn't necessarily have a valid signature for a volunteer on.
No,
the
I think
records.
that's correct. If they're paid, they're gonna have
Right.
the information
If they're
that we
not, they
need.
won't.
And if they're not paid,
Yeah.
then we may not be able to get anything.
Yeah, so the only thing that we're able to discern, I mean, I'll just read it. It says, with regards to the first request, the Cornell West for President campaign did not retain any firms, companies, or organizations to circulate Dr. West's petition and collect signatures. That said, the campaign is appreciative of efforts to get Dr. West on the ballot, and as a courtesy to the board, the campaign has endeavored to collect supporting information to assist the board in confirming the genuineness of signatures for the circulators. So based on that, we can't determine if the individual circulators were paid or not.
The ones that were missing, yeah.
Right.
I'll make a motion.
You will?
Yeah.
Good.
I move that we direct our attorneys to send a subpoena to serve a subpoena on the Cornell West campaign to provide the signatures which we previously requested and which were not provided.
If there's discussion on the motion, I'd like to be heard.
I'm
If there's
sorry.
discussion on the motion, I'd like to make a quick clarification. As the statute and the rules lay out, we can't actually send that subpoena. The board would be the one issuing the subpoena. So it would be the board issuing the subpoena that we would
Okay.
serve
Okay.
upon whoever you send it to.
Thank you. So I will modify my motion and say that I move that the board issue a subpoena to the Cornell West campaign, which we would send through its attorney who represented it in Michigan, directing the production of the information previously requested of the campaign, which was not provided in response to our request. The subpoena would list the names, I would say the subpoena would list the names of the circulators whose signatures we requested, which were not provided. So that would be, the appendix to the subpoena, or, yeah.
Do you need, Adam, do you need a bit of time to put that into format then?
The motion or the
motion.
subpoena? Nope, I got the motion.
Good.
Thank you though, appreciate it.
You were typing very rapidly there. I thought I'd help you
I'm
out.
cleaning up what I wrote
Oh,
because
gotcha.
it's not quite legible, but thank you, appreciate it.
I would second the motion.
Motion has been made and seconded. All those.
So discussion, I just have a couple of
Yeah,
questions. Well, what is, I'm not an attorney, never sent or received a subpoena. Is there any significant costs associated with sending out a subpoena?
That's a question to me, I guess, that we're not paid by the hour. So, you got our time, I guess.
I'm used to deal with hourly attorneys. so.
We can talk after the meeting. I think we'd just be talking about postage and the cost of the paper and ink for it.
Okay, I just am not sure how much we will end up getting back. So if there was significant costs,
The
I
cost
think
of receiving the subpoena will be much higher.
Yeah.
You guys will send it. The paper stuff would be sent through the bureau.
Yeah, I mean, we mail a lot of things, so I think the cost would probably come in the time, if there's follow-up on it and
Sure.
enforcing the subpoena, that's probably where we would start to see more resources being used.
Is there any other discussion before we vote on this? It's been moved and seconded. All those in favor?
Aye.
Aye.
This is important because I don't think the board has sent out a subpoena before, so
It's the first
We're
one.
tough guys.
I think the issue is a strong enough one that we're going to
Right.
encounter it over and over again. And unless we take it seriously, unless they know, the campaigns know that we take it seriously.
Exactly.
So. Any, for the point, other business was presented to the board, and I do have, Renita, did I pronounce that correct? Yes. Renita, if you would come up and I need you to state your name and spell your last name for the court report, for the board report.
Renita Bonadies, Bonadies.
Mrs. Bonadies, Ms. Bonadies, we have a number of documents. You had emailed some documents.
Correct.
And then you presented some when you arrived this morning,
Yes,
which I apologize, we've only had a few minutes to look at, so.
understandable.
Could we
It was
just go the
more
other
just,
route and ask you to tell us what's on your mind?
well, I was gonna just read my public comment and then that's the supporting documentation for what I was gonna present, so. Good morning, Renita Bonadies from Homer Township in Midland County. I sent an email to this board back in November and again in January with my concerns and questions about some things I witnessed in Midland County at the Board of Canvassers meetings following the November 5th election. And I did attend the Thursday and Tuesday meeting that followed. I also sent a packet to the Secretary of State and Attorney General's offices with no responses. And I also emailed the Bureau of Elections because I've been trying to call and find contacts. First, I was on the ballot as a write-in candidate for county clerk. I was at the closing of the polls on election night for the early voting center. I knew the number of total votes I received, but they were not separated by townships and precincts, just a total. I attended the Board of Canvassers meetings and questioned how they could report the write-in votes by precinct, and I was told that they didn't need to since early voting was a precinct. I asked again at the second day of the Board of Canvassers meeting and was told that they had done it properly. The official election results for Midland County did not adjudicate the write-in votes for any race, which included the presidential, Senate, and county clerk races, because they all had write-in votes at early voting and they were not tallied at the precinct level. Is this really the way these votes were to be tallied and reported by the Board of Canvassers? Is there a required adjudication process for invalid votes to count as undervotes? Our records simply show all write-in votes for all races. Also, there are no names of the actual valid write-in candidates that received votes, like in the presidential race. I did check out other counties and spoke with people on their boards, and they said that they did tally their early voting by precinct, and their county official results reflect all races and precincts with that information. Also, I've been attending the Board of Canvassers meetings for the past 2 years following the elections. I noticed that they are to be public meetings. Our board is separated into 2 groups. Each group has 1 Democrat and 1 Republican on the team, and each reviewing about half of the precinct records. The 2 groups sit and speak so softly to each other that the public has no idea what's being discussed. It's more like watching 2 subcommittees simultaneously having a meeting. It is certainly not all 4 listening and reviewing each of the precinct records as 1 board. And I do have video recordings of all of these proceedings as well. Is this the proper way to conduct this post-election canvass? Can they certify that they have reviewed all of the records when they only reviewed half of them in 2 groups? These are a few of the questions I have and have not been able to get a definitive answer. Finally, all of the municipalities contracted with the county to run the early voting for them. Their contract was for the county to produce the same results they would have received had they done the early voting polling themselves. Instead, the county could not produce the precinct level results for the write-in candidates on the ballots. My question is, did they breach their contract? I know our township paid $7,500 for them to do that service for them, and yet they cannot produce a precinct level result for all of the races on the ballot. Thank you.
Questions?
I have a question for Mr. Fracassi. did the board respond, or excuse me, did the Bureau respond to an inquiry from Ms. Benitez about the procedure followed by the Midland County Board of Canvassers?
So a couple of things. So we have, there have been a number of FOIA requests that have been submitted. We've responded to the FOIA requests. As far as the first email that I have is from January 14th. It does look like, based on what I've seen that's before you, it does look like the wrong email was used previously. So I don't have any record of getting anything prior to January 14th. It does not look like, though, that we've responded since January to the January 14th email at this time.
Let me just ask another question. It is true, is it not, that the Bureau of Elections provides to the counties guidance for how county canvassing boards are to conduct their canvasses?
Yes, that's accurate.
And there is an official manual, I believe, for the county canvassing boards.
Yes.
Does the board have any, or perhaps I can ask the attorneys this, does the Bureau or the board have any jurisdiction over what the county canvassers are doing? That, Mike, you know, what I'm really asking, I understand that Ms. Benitez has a concern about what the county canvassing board did, but I don't think we have anything to do. That's not our responsibility, nor it's my understanding, and I would want confirmation of this. I don't think there's anything that we can do about it.
I'm not aware of the board having supervisory authority over the county boards. And following an election, there's the canvass process itself with the board reviewing the canvass returns. But I don't think beyond that, I don't think the board stands in like a superintending role over how the county boards conduct their business.
The question that goes with that, in the event that someone has an issue that they're pointing out with a county board that we don't have the ability to step in on, what would be the normal next step to follow? Would that go through the Secretary of State's office, through the Bureau of Elections, and then Sec State, or if somebody has a problem with a county?
I'm reluctant to speak extemporaneously without looking into it. I think you could direct concerns to the Bureau and to the Secretary of State. It may also be worthwhile for a person to contact their own attorney if they're looking to compel the board to perform a specific duty that might arise in some type of legal action that they would need their own legal representation to engage.
From our standpoint, I mean, we certainly can provide instructions to the clerks. We do sometimes in the context of post-election audits identify procedural issues which can be correct, you know, which will assign training and provide additional guidance on. You know, additionally with this, I mean, this was the first major election where we had early voting. So that did raise a lot of new issues about organizing results by precinct that we're certainly going to look at for future rounds of training. In terms of the result, I mean, ultimately, there is always the ability to request a recount if someone contests that, you know, doesn't believe that the ballots are tallied properly, and you still have the paper ballots available. So ultimately, you still do have records that you can review to determine exactly which write-in ballots were tallied, you know, which were cast in which precinct, you know, from which precinct, and you also have the ability to contest those during the recount. And then there's also obviously the ability to file a lawsuit. So those would be the ways of contesting the actual outcome. But in terms of the procedures, yeah, it's certainly something that we can look at and see if there's additional ways that we can make more clear the results. One of the other issues, frankly, is that we have the same 14 days after the election to complete the post-election canvasses that we had before early voting, and now we have a whole other set of results. So clerks have supported legislation to expand the canvass period think the Department of State supports that as well, but we're sort of stuck with what we have right now.
May I make one additional comment? I guess my point is, it's not the results of the elections, it's the process that was used by the Board of Canvas. I mean, it would be equivalent, and I've watched the State Board of Canvas after the election. It would be the equivalent of you breaking up into two teams and discussing the results in a quiet session so that the public can't even hear what's going on. We are not able to hear what's being discussed, what votes are there, any issues they're having in the poll books, if anybody wrote any notes. We don't hear any of that. And again, it's questioning if this is indeed an open meeting according to the way it's defined. Then how is it an open meeting if the public sitting there can't even hear it? And like I said, I have the recordings where you can tell you cannot hear what's being discussed as they review each of the precincts. So we don't even know if there was an issue at a precinct because it's whispered off in one of the groups. So it's the process that I'm concerned with. I mean, I had one county actually, when I called to verify how they did it, they were actually going to take a field trip to Midland to find out how we got done so fast. And I told them, I said, I can tell you it's because we break up into two teams and they're done quicker than almost anybody else. It takes a matter of a few hours for them to complete their canvas. So again, it's not the results of this particular race. It's the process that's being used. And I've sat through these for 2 years now, and it's always the same process. I did point out at this last one that they didn't even have public comment. And I'm like, this is an open meeting act. You have to have public comment. So they did actually include that at the last one. But it's again, educating the public. And if it's an open meeting, why is the public not able to hear what's being discussed by the board? So, and yes, I understand early voting is a new issue, but I also checked with the other counties to see how they handled accounting for their processes. Our early voting produced a single document with just totals. They never produced anything that broke it out by precincts. And when I questioned why the Dominion tapes weren't used to determine that for the write-in candidates by precinct, they told me I didn't know what I was talking about. And that our machine didn't produce it, even though I know another county did use their machine tapes to actually produce their write-ins by precincts so they could report them properly. So again, it's the process that's being used. Do we need more details in our documentation for this process? Perhaps, but those are just observations I've had, and I was curious, and I've been asking questions and sending packets, Secretary of State, Attorney General. Nobody was responding, so that's why I'm here today, to just bring it to your attention.
We appreciate you bringing it to our attention. That said, I'm not sure we have a direction for you other than as Mr. Brillis suggested, you can certainly retain an attorney locally.
I realize we can always spend money and keep attorneys
But your
well
relationship
employed.
with your county clerk is not such that you can sit down and.
I have attempted multiple times to correct this, and I have been met with a fair hostility about it. And that's why he mentioned FOIA request, qualified voter files. I work with election data. I have it denied frequently locally, and I have to run it up to the state to find out that yes, indeed, we can get that data locally, and then I have to bring it back down. So I've been doing this now for a couple of years, trying to learn the process. So
Are you thinking of running for county clerk?
not sure if that's what I'm waiting to see how this is all handled.
Well, that would be another approach.
So,
Let me
But-
say something. Yeah, I just want to note that there are 83 counties in Michigan, and that means there are 83 canvassing boards.
Right.
And they determine as best they can how to undertake the canvas. And it's a formidable process, particularly I've seen the canvas in Wayne County where there are teams of people reviewing every single poll book. So the county, asking a small county how they do it as opposed to how Wayne County does it, for example, or Kent County, Everybody is going to do it a little bit differently in accordance with their circumstances and how many people they have doing the work.
I understand, and that was why I looked for counties that were comparable size. We also just reduced from 44 precincts. We eliminated some within the city. We went from 19 to 10, so they just reduced it to 35 precincts. And like I said, we're done in just a couple of hours. It's not that it's a long process in our county. So again, why can't they all sit there as a board speaking into mics loud enough that the public sitting there can hear what the issues are and what's happening? So, so yes, I'm aware that the county size would vary greatly for how that process is carried out. So,
Thank you for taking time to come and see us.
thank you.
Is there public comment? Any public comment?
Well, you have other businesses.
What did I miss here?
Number 9.
Oh, you know what? You are correct. Yes. Number 9, is there any other business?
Yeah, there is something that I want to address. I think it is necessary to briefly address Governor Whitmer's veto of a number of petition bills which the Board of State Canvassers supported. Referencing the 2022 signature fraud scandal, she stated that, quote, "These bills fall far short of the serious need to address this fraud, to restore public trust in our nomination petition process, and to protect voters and our state constitution. Namely, these bills move Michigan in the wrong direction by authorizing sampling procedures instead of requiring exhaustive review of signatures to ensure no fraud exists," end quote. The governor was mistaken, and I believe she was ill-advised. She failed to understand that the bills went in the right direction to address signature fraud, and I want to assure the public that it can trust in the nominating petition process. It is the responsibility of the Board of State Canvassers to canvass petitions to ascertain if they have been signed by the requisite number of qualified and registered electors, both with regard to initiative and referendum petitions and nominating petitions. The board takes this responsibility seriously, and the courts have repeatedly recognized that the board has considerable discretion in its choice of the means to exercise that responsibility. The Bureau of Elections does the actual work of reviewing petition signatures for the board. Following the fraud scandal in 2022, which it must be noted the Bureau of Elections detected in its review process, the Bureau and the board took steps to determine what better processes could be used to detect forgeries and thus prevent such fraud in the future. The Bureau of Elections retained a consulting firm to review the signature verification process. For decades, random sampling has been used to review initiative and referendum petitions. The consultants recommended the use of random sampling for review of state nominating petitions as well. This recommendation was presented to and considered by the Board of State Canvassers. We then took additional steps to consider the recommendation. We had the statistical analysis supporting that recommendation reviewed and validated by a Wayne State University statistician. Members of the board, Chair Hauskamp and I, convened a meeting with election lawyers who practiced before us to discuss this proposal, and it was broadly supported. To evaluate the efficacy of random sampling, we requested that the Bureau test it on one of the rejected gubernatorial petitions, and the procedure identified even more invalid signatures. We also looked at other states and determined that many use random sampling to validate signatures. Having thoroughly examined our existing processes and the opportunities for change, the board concluded that the use of random sampling for nominating petition signatures would result in a far more thorough and effective review of petition signatures than the Bureau had been able to do in the past, and we voted unanimously to adopt the procedure. While it was not strictly necessary, the board also decided to support an amendment to the election law, authorizing it at its discretion to use random sampling for nominating petitions and also for initiative and referendum petitions where random sampling has been used for decades. All 4 members of the board, Republicans and Democrats, appeared together before the House Elections Committee to support this recommended amendment and others. In addition, a working group with representatives from the Bureau, the Secretary of State's office, the House Election Committee, and others, met over many months to review and update the election law provisions regarding petitions. The board recommended the approval of these changes, which were passed by the House and Senate, but then, as noted, vetoed by the governor. We expect that in 2026, the board will be faced with the task of reviewing petitions for ballot proposals and nominations for governor and Senate with upwards of 2 million signatures. We may see more than 500,000 signatures on nominating petitions alone. The board has concluded that random sampling is the best procedure currently available to validate petition signatures. We will use this procedure as we voted to do, and the public can be confident that we will be exercising our critical responsibility to determine whether petitions are supported by the required number of voters. However, we will continue to look for ways to improve our canvassing processes. And as Chairman Hauskamp will discuss, rapid developments in artificial intelligence may well give us the tools to more efficiently and exhaustively examine petition signatures in the near or reasonably foreseeable future. Chair Hauskamp?
No, I totally agree with where you're at. That was a beautiful statement, well stated. And as we've talked over the last couple of years, the technology is advancing. Michigan is, and the governor has stated that Michigan should be the leader in technology, should be a nexus for where technology is born and in business and government both. So I think moving forward, one of the opportunities we have over the next couple of years is to take not only the random sampling forward, but also take through technologies such as signature validation by AI and the ability to do very high speed processing of signatures submitted. Will that eliminate the need for human involvement? Will that eliminate the need for challenges to be filed? No. What it'll do is it will simply shrink the universe of signatures that may be subject to review. Instead of having to look at 500,000, you'll have already pre-validated 490,000. And this seems to be the direction that Michigan needs to go, and it needs to be a leader in bringing technology to the table. It needs to be a leader in things like the random sampling and saving the time, and not to mention the fact that the random sampling was initiated originally through Bureau of Elections coming to us and saying, we simply don't have the turnaround time. We don't have the staff available to do justice. Great statement. Thank you.
Chair Hauskamp has told me that he's going to demonstrate to us
Not today.
how AI is going to work, right? And I am really excited about the possibilities that are before us to go in this exciting direction, because technology should certainly enable us to more, as Member Hauskamp or Chair Hauskamp says, to more effectively review petition signatures. But it's a huge job, an absolute huge job, which has to be undertaken in a very short period of time. So we are going to use random sampling. The public can have confidence, as I said, and we will continue to work on improving our process. I hope.
Yes.
I've had my say.
Nothing to add.
All right.
Is Mr. Gallant?
Is Mr. Gallant on?
He is not.
He is not here today. Is there any public comment? Anyone here? Discussion. Did you want to
Say something?
Yes.
Are you gonna swear? Are you gonna swear him in?
I should, but I
There
won't.
were like 6 things that I want to critique you guys on. No, while I'm here, thank you very much for the resolution. Welcome Heather and Paul. Good luck to you. It's going to be an interesting 4 years. And just again, reiterate what a pleasure it was mostly to serve on the board. And and get to know these folks. I think it's a very prime example of how government can work in terms of a bipartisan fashion and get the work done that you need to get done. Not by giving up on your principles, but realizing you got to find a way to get the votes necessary. And I think we did a great job with that. And to the staff, that just tremendous work, providing us the information that we needed. You work very hard, you're very responsive, and never once felt like I was getting different information because I was a Republican than maybe the Democrats were getting. And I think that needs to be stated publicly that I may disagree very strongly with the head of the department, but the staff, you were always very kind and responsive and on top of things. So that's all. Thanks.
Thank you.
She can't let Tony have the
Well,
last
no,
word.
it's not that. Actually, Tony got up, you called Tony up first, so that's your fault. No, I think Tony kind of encapsulated everything that, want to say. I mean, even more, having been the longest serving board member for 12 years. So I still remember when we actually got physical packets and we'd have to have the mailings and all of that. But, staff here and our attorney general representatives too, like there was it's any answer you wanted. I am a little bit disappointed that no one asked any questions about the system that you guys approved. I was going to ask about the voice assistants because the 5.17 doesn't have voice assistants, but I don't know if the 5.2 does on the Dominion. I know I went right into the documentation that's actually public and then was wondering if the new one actually does. So I will. No, I told David I wasn't going to ask him any questions too. To the new members, I'm going to tell you what was said to me at my first meeting by a lawyer who normally came in front of us who retired. Why? That was the question. But no, it is going to listen and ask questions and enjoy your time. It'll definitely be different. And we're going into different times. And it's very interesting to see what was brought in front of you today, because it'll change every single time. And we're always here. I mean, I'm always available. So you'll probably see me sitting in your room, not critiquing, but paying attention, because this still is and will be a very important part. And having public comment and questions that come from everyday people wondering what's going on with this board. So thank you.
Thank you, Jeanette.
There's no other business. I take a motion to adjourn.
So moved.
All in favor? Yep.
Aye.
Adjourned at 11:35.